Facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 14th, 2025, at approximately 12:32 a.m., an officer observed the defendant outside of her vehicle twerking at a red light intersection. The defendant
Twerking?
Whoa, that's a first. Twerking at a red light. Talk about drawing attention to yourself in your car. Viewers, have you ever heard of a DUI case starting like this? Let us know in the comments.
Yes, sure. The defendant then returned to her car and drove southbound down Montrose Boulevard. The officer observed the vehicle failed to signal a lane change multiple times. A traffic stop was initiated. Officer observed the defendant to have the mild odor of alcohol upon her breath, slurred speech, and glassy eyes. The officer asked the defendant to exit the vehicle, and the defendant stated she had 2 glasses of gin with champagne at a bar. SFSTs were conducted. 6 out of 6 clues were observed on the HGN, 3 out of 8 clues observed on the walk and turn, 2 out of 4 on the one-leg stand. The DIC was read and the defendant consented.
Interesting twist. Initially, consenting to a breath test, but later revoking it, can raise legal issues. But remember, once you blow, you can't undo it. The blood warrant. That's the state's backup plan.
To a breath test at 1:18 a.m. Then at 2:20 a.m., she said she did not consent. A blood search warrant was signed and executed at 3:06 a.m.
Pay attention here. These are standard bond conditions, but they're serious. Fail a random test. Straight to jail. And no more freebies with PR bonds. This judge isn't messing around.
All right. Any prior DWIs?
No prior, Judge.
License?
Eligible.
Ms. Bookman, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to
Probable cause was already done. They're rereading it for transparency and for Mr. Garcia to hear it in open court. That's due process in action.
randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, you will go to jail. No more PR bonds. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer, ma'am?
Yes.
Okay, we will give you time. So what I will have you do is I'll have you go to Victoria, sign a reset. You'll get with Fleischer your bond conditions, and after that, you'll be free to go.
Thank
When you
you.
come back, please have a lawyer.
Okay.
Your lawyer came by here yesterday. We did probable cause. I'm gonna now find probable cause. I mean, let's do it just for,
Okay.
so he can hear it, but you have the right to remain silent. Anything you say can or will be used against you, sir.
On March 15th, 2025, an officer was working at crash scene in Pasadena, Harris County, Texas. At approximately 1:15 a.m., the officer heard tires squeal and a vehicle collision a short distance away. The officer observed a vehicle had collided with a fully marked police vehicle with emergency lights activated.
Well over the legal limit. With a police cruiser involved, and those back numbers, Garcia's looking at more than just a traffic citation. Think he can bounce back from this? Let us know below.
The officer observed the defendant, the driver, and sole occupant to appear confused and have glassy eyes. The defendant exited the vehicle and the officer observed red glassy eyes, slurred speech, uncoordinated and lethargic movement, and the odor of alcohol emitting from his person. The defendant admitted to drinking 2 beers. SFSTs were conducted. 6 out of 6 clues were observed on the HGN, 3 out of 8 clues on the walk and turn, 2 out of 4 on the one-leg stand. The DIC was read and the defendant consented to provide a breath specimen. The results were .134 and .123.
No prior DWS, right?
No prior DWS.
Okay, Mr. Garcia, I'm going to find that there's sufficient probable cause to go forward with your case. I am ordering you not to consume alcohol. Do you speak English, right? Okay, I'm ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond and put you in jail. No more PR bonds. Do you understand?
2 charges here: evading arrest and carrying a weapon. But watch closely. The judge starts to question whether the officer's actions even hold up in court.
Do not pick up any new cases. You've got a great lawyer. Listen to him and he'll take care of you. I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. LeGrand and he'll tell you when you have to come. All right? I'll have you go to Victoria Center reset. You'll get with Fleischer for your bond conditions and then you're free to go. Mr. Gasson, you're charged with 2 cases. You're charged with evading arrest or detention and unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 14th, 2025, an officer observed a vehicle speeding on Gulf Freeway feeder by radar device going 72 miles per hour in a 40-mile-per-hour zone. The officer then observed the vehicle turn left at a red light. A traffic stop was initiated. The officer instructed the driver to step out of the vehicle, and the officer began to detain the driver. As the officer was detaining the driver, the front passenger, the defendant, exited the vehicle. The officer instructed the defendant to return to the vehicle, and the defendant ignored the officer's instructions and started to walk away. The officer ordered the defendant to stop, and the defendant started running northbound. The officer observed the defendant place his left hand near the front of his waistband and throw a small black and blue object near a fence. The officer informed other officers. This
isn't just law, it's life advice from the bench. Some judges use the moment to teach, not just punish. Think that speech will stick with the defendant.
Officers of the defendant's location. Officers observed the defendant running eastbound on the 3,300th block of Scott Street and attempted to apprehend the defendant. The defendant was apprehended at the 3,100th block of Milby Street, approximately 0.2 miles away from the scene. The officers searched the area and located a firearm. The officer remained in visual contact with the location and no individuals approached that area.
What are they doing wrong? I mean, the officer just stops them and just arrests them?
Sexually oriented enterprise violation at ... the library. Yep, you heard that right. But is it legit? Even the judge isn't convinced. He wants the statute pulled. This one's murky.
What for?
I'm not sure why the officer immediately detained him.
Really? Is that what we do now? We just stop and arrest? No. I'm going to find no probable cause in your case. Just be careful, man. If you have a gun, God forbid you use it, something happens, you dig yourself in a hole. Come on, man. We got one life. Be smart. Go to school, get some knowledge, make a ton of money, you know? Take a seat. Good morning, Miss Hayman. You're charged with violation of a sexually oriented enterprise. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. All right.
On March 15th, 2025, the defendant was performing at the library a sexually oriented enterprise without a license to entertain displayed on her person in violation of Ordinance Section 28256A. And that ordinance states that each manager or entertainer shall conspicuously display his or her personal card upon their person at all times while acting as an entertainer or manager
That's
of the
where I
enterprise.
Am I correct that you have to have a license, correct?
I believe that is the code, yes, Your Honor. Yes, you have to have a license. I will double check that though.
Yeah, let's do this. I'm going to appoint you a lawyer right now. We'll dig deeper into this because I want to know if there's sufficient probable cause to go forward. We'll pull the statute. The problem is I got a whole crew of people that we need to get through. It's going to take some time, so just be patient and we'll get.
Chase alert. The officer had to go 100 miles per hour just to catch up. This case could have ended in tragedy. Reckless driving isn't just a fine, it's a danger multiplier.
Your Honor, I do have statute but if you want to leave.
But let me get a defense lawyer just in case. Do you mind appointing our lawyer? Or if you don't be so kind. What?
Page 9, Otto.
Good morning, Mr. Otto. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 13th, 2025, at approximately 10:15 p.m., an officer initiated a traffic stop at the...
That right there, that's a judge issuing a real-life warning. Lose your license in a major city. That's like losing your lifeline. Comment if you think that's a fair consequence.
5,804th block of Southwest Freeway on a black Alfa Romeo. The officer observed the motor vehicle weaving in and out of traffic at high speeds, endangering other motorists on the road, almost striking multiple motor vehicles. The officer had to increase the speeds up to 100 miles per hour to catch up to the motor vehicle and traveled about 6.1 miles. The defendant admitted to driving over 100 miles per hour in an attempt to catch up with another motor vehicle. A NCIC TCIC check revealed the motor vehicle had no valid insurance. The defendant was identified by his Illinois driver's license.